other matter I wanted to bring to you is just a reminder that we are going to be changing our meeting schedule beginning next month. Previously, we have been meeting the second Thursday of every month, at least to the extent that we could, could arrange to have a quorum present, and at times we're certainly flexible enough to change it if necessary. We are, in order to accommodate everybody's schedule, we're planning on a meeting that will occur on the second Wednesday of every month, beginning next month, which is would be August 13th. If there are any, anyone has any changes in their anticipated schedule and that could not work out, please let me know, and we would be happy to work with all of you to ensure that everybody is able to attend future meetings. And that will conclude.
Is that fine? By the way, I know that we had the commissioner had an issue with the Thursday dates, and again, we'd like to keep them the same so that the public is very much aware of when we're having meetings. So I apologize that we have to change the date because I think the public was getting used to the second Thursday of every month, but we will make the announcement. We'll put it in the announcement that we will be making that change to the second Wednesday of every month at 10 a.m. and start at the same time.
All right. And that will conclude my report. Thank you, Commissioners.
The next item we have are the complaints in open session. Ms. Roberts, good morning.
Good morning, everyone. The first case in open session is 1342. This case is before you for the ratification of the letter of instruction. The case was filed back in November of last year. If you recall, actually only the chair I think will recall, in the May meeting, this case was on for ratification of the letter of instruction, but the day before, Mr. Melton, the complainant in this case, filed quite a lengthy letter, essentially arguing that the probable cause determination was improper or incorrect in his opinion. And for that reason, you gave yourself a little more time to review that letter and then come back and instructed me to put it on today's agenda. Again, it's here for ratification of the letter. It is our position that first and foremost, the rules of procedure do not in any way allow for an appeal of a probable cause determination or probable cause hearing. For obvious reasons, if every complainant were allowed to challenge probable cause, or every respondent were allowed to challenge probable cause, every probable cause hearing would be never-ending. Secondly, I have read the letter, in fact, and our position remains the same in terms of the facts and the resolution of the case. So I ask at this time that you go ahead and ratify the letter of instruction as written. Mr. Melton is present. He came up during the public comment section, asked to speak now. I would just ask that he be limited to 3 minutes as we typically do for the public comment section.
Mr. Melton.
Thank you, Mr. Chairman. Members of the Commission, again, for the record, my name is Dusty Melton. I live at 3430 Poinciana Avenue in Coconut Grove. And I appreciate the opportunity to speak to you at this time when you're taking up this matter. Let me underscore the fact that I'm very well aware that 3 members of the Commission were not participants in the adjudication of this matter. But we're all here today and we're looking at it fresh and we're all participating. For everything I've been told, Ms. Sarah is a very nice person and a very fine attorney. I've never spoken to her. Consequently, I've never collaborated with her. I've never competed with her. And I had no client interest whatsoever in this particular procurement. But I'm passionate about the rule of law, and I'm here today in support of the rule of law. And I'm hopeful that you all will see it my way at the end of this brief presentation. The facts in this case are remarkably straightforward. The outcome could only be described as a sequel to Alice in Wonderland. Ms. Sarah was retained by her client sometime around June of 2012. She sent 4 letters to county officials, including the mayor and airport director, trying to affect the outcome of a procurement at the airport prior to registration. And the lobbying rules that you are sworn to enforce, at their simplest, require registration prior to lobbying. I filed a complaint because I was offended by her violation of the county code. In her response letter to my complaint in January to the commission, Ms. Sayre offered two excuses for not registering timely. The first one was her name appearing on her client's proposal, Appendix D, which afforded everyone the right to appear before the evaluation committee. It lasted about an hour, and it's an authorization to show up one day in one room and speak to one group of people and nothing more. In her January letter transmitting this to the commission, Ms. Sayre wrongly asserted that no further registration was required. Her second excuse was a specific reference to page 31 of the RFP, and she put a star by that paragraph that gave instructions to proposers. Ms. Sayre is not the proposer. Her client was the proposer. She was the lobbyist. If you look at the RFP, which I presume she read, and you come back to that same page 31, her paragraph, just drop down 2 paragraphs, and the RFP instructs lobbyists, such as Ms. Sayre, that we also have rules for the lobbyists, which are distinct from rules for the proposer clients. And it says you've got to follow them. And it directs your attention to Appendix H. And Appendix H is 6 full pages of the rules governing legal behavior of lobbyists, including a requirement to timely register. She was hired in 2012. She started lobbying in 2013 and registered in October. The lunacy of the recommendation that the County Internal Services Department be instructed to fix its paperwork is stunning. The language that the letter of instruction says should be sent to the county for its inclusion in future RFPs is in those 6 pages of Appendix H, including the last line, and that's exactly the clause that the letter of instruction recommends that the county pay attention to. So I appreciate this opportunity to speak to you. The explanation of why Ms. Sayre did not timely register makes no sense. Appendix D is a one-time appearance and no further, and the other page that she cites are instructions to proposer, which she is not. These are the rules governing her behavior, and she violated them. And not sanctioning violations of the ethics code is not what this commission should be about, in my respectful opinion.
Thank you, Mr. Melton. Ms. Ramos, do you have any responses?
I don't, because again, my position is that we are not reopening probable cause. The letter of instruction is on for ratification.
Any comments from my fellow commissioners?
No, I guess you just answered it, because I was trying to figure out procedurally what we were supposed to be doing. I appreciate the visual aid, and I read the very lengthy set of documentation, but I wasn't sure what specifically we were supposed to do.
If you allow me one minute to explain. When a citizen files a complaint, the staff has 60 days to investigate the complaint and render recommendation of probable cause. We then have a probable cause hearing. That was held in this case, I believe, in April of this year. After that time, depending on what happens, in that particular hearing, no probable cause was found, the complaint was dismissed, and a letter of instruction was issued, essentially, or you asked me to draft a letter of instruction. That's where we are now. As I mentioned in our rules of procedure, there is no avenue by which an appeal, essentially, of probable cause occurs. And so, at this point, I simply ask that you review the letter for ratification.
So Mr. Melton was speaking to just amplify the record for us to ratify the letter that's already been written?
I'm not sure what Mr. Melton's intention was. I'm sure he would love to reopen the probable cause hearing. Our position is that that's not proper pursuant to the rules.
Mr. Melton, could you please come up, sir?
And for the record, Ms. Sayre is also present if you'd like to hear from her.
Sure. Thank you.
Yes, sir,
I
Mr.
just
Chairman.
I just want you to be able to address if there are any questions from my fellow commissioners.
I appreciate the opportunity.
And you understand that I'm completely new to this process.
I
I'm
said
just
that at
trying
the
to figure
outset.
out
I said that at the
procedurally.
outset. If I speak broadly about this matter, I understand that 3 of you are brand new to this particular case. From my May 5th letter, or whenever, early May letter to Mr. Centeno, copying all of you, and my appearance here today, it's clear that I vehemently disagree with the outcome, that there was no probable cause. There was a clear violation in 4 letters that were communicated to county officials, including the mayor and the airport director, trying to affect the outcome of a procurement prior to registration, in manifest violation of the county code and the rules that you all are supposed to understand and enforce. It's not complicated. It's very straightforward. The determination in the April 16th meeting, in the closed session, from which I, as the interested party in the complaint, was ejected pursuant to your rules, which is another matter altogether, a decision was reached by the commissioners present at that time and Ms. Sayre and your senior staff that her excuses outweighed the law, that there was somehow confusion and the county should be instructed to improve its documents, which are flawless in this case. I strongly and totally disagree with the outcome on April 16th. If your rules not allow you to revisit, then I'm stuck. But so are you all, if you ratify this letter. Because this letter is nutty and reaches and suggests the county is at fault when the county's documents were not. And I'm here to answer any other questions you may have.
Any other questions?
Thank you so
Mike,
much.
I just wanted to make sure that my fellow commissioners who were not present understood what your purpose was here today. So essentially what you're looking for is a
Unraveling of the decision, and not transmittal of a letter to the county, but a letter instead to Ms. Sayre.
And/or, is that what you're looking for?
No, don't send a letter to the county. County didn't do anything wrong. County's documents are crystal clear. Her behavior violated the county code. A letter should at least go to her. Now, I'm not asking for any stiff penalties, but you're sending your letter to the wrong people, in my respectful opinion.
That clarifies it. Thank you, sir.
Thank you so
Thank you for your time, and I'll be happy to hear from Mr.
Mr. Chairman, may I address the board?
Yes.
My name is Diana Sir.
Oh, isn't that special?
I'm sorry, Mr. President?
No, I said, isn't that special? Somebody gets walks up, yeah. Do we start a clock?
For the
Mr.
record, Ms.
President,
Sayre is a respondent in the case.
I understand. I'm the one in charge here. I appreciate everybody's comments. Let me be the one who directs this. Ms. Sir, what comments do you have?
Thank you. My name is Lillian Sir. I am so overwhelmingly impressed by Mr. Melton's interest in upholding the county's lobbyist registration rules. It's quite admirable, except that in this case there were 36 submissions on this RFP. This is an ongoing process with MDAD on an annual or more than annual basis when they put out an RFP. Inside all RFPs is an Exhibit D where you must include everyone, including attorneys, that will be representing that particular respondent to the RFP. It is standard procedure with MDAD. You fill out this form and you do not have to submit any other documentation to the county. The fact is that the county's main lobbying rules and the information that is included in these RFPs that is also issued by the county are not jiving. And in particular, in Exhibit D and elsewhere in the RFP, it requires you to then register in addition with the county only if you will be going before the commission, a county board, or a county committee, period. I followed the letter of the RFP, as did everyone else. So for Mr. Melton, who I have never seen before until today, to have singled me out brings up a whole other possibility as to why he's doing this. One of my clients, which I won the bid on, had a second place bidder that's been trying to knock him off his spot for a very long time. Whether or not Mr. Melton is involved with that particular respondent, I cannot say nor can I prove. But it just is such a coincidence that I am the only one he is offended by, when everyone else who has submitted for this particular RFP, which is now 2 years old, and since that time, I will bet you
that everyone else that has submitted on other RFPs followed the same rule. Now, it is unfortunate that I'm the one who has been dragged through the mud on this, when I have never had any other issue with the county or any other ethical board. But the county's procedures, both in the main county's code and in the MDAN's requirements for submission, are not jiving. And that's the county's doing, not mine. I followed the instructions of the RFP to the letter. And it was not until the decision was rendered by the mayor that the lobbying began. And that is when I filed the lobbyist registration as required by the RFP. Thank you.
Thank you, ma'am. Any of my fellow commissioners have any questions?
I have a quick question, Ms. Ramos. So, would it be fair to state, looking at your letter of recommendation, two
It's a
things?
letter of instruction.
It's letter of instruction, sorry. The two things. Number one, you're basically, your argument, as I understand it, is that the provisions really do not permit a review of the decision that was taken when three of the four that are here were not here, correct?
That's correct, sir.
And number two, in your letter of instruction, you're making reference to section 2-11.1(s)(2). The recommendation you're making to the county is that that language be included within.
In Appendix D, which is the document that seems to have caused the confusion in this case. If I may, in my recommendation for no probable cause, essentially what we did was we gave Ms. Sayre the benefit of the doubt. She came in and explained to us why it was that she was confused by the documents. When we looked at them candidly, so were we. They are unclear. And so we felt that Ms. Sayre, having never been before this board, articulating a reasonable interpretation of what's on that appendix, that it would be unfair to proceed against her. And for that reason, I recommended a finding of no probable cause. The board at the time agreed, dismissed the complaint, and went so far as to ask me not to name Ms. Sayre by name in the letter of instruction, because they felt it was unfair to her and her reputation, and that the letter be drafted in the way that I drafted it.
Just one other question, I guess, and this language you're referring to, beyond Appendix D, I guess your recommendation would be that future RFPs not have this dichotomy, if that's the right terminology.
There's parts of the RFP, as Mr. Melton stated, that do quote essentially our code properly. It includes those meetings before county officials on matters that could come before boards. But other parts of the RFP and Appendix D leave that last sentence out. And that is what in fact created the confusion in this case.
Any other questions from my fellow commissioners? Do I have any motions from my fellow commissioners? Questions?
I have one more question. It's another procedural question. So it's either the letter is ratified or the letter is not ratified. And
Correct.
if the letter is not ratified, the case has still been dismissed against the attorney, Sarah. And then there's no instruction to the county if the letter is not ratified. Is that what happens?
Well, yes. Essentially, the first decision that was made was to issue a letter to the county. You certainly can change that today to not issue a letter at all. You can ask me to revise the letter to state something differently. It's your letter, so you're welcome to revise it any way that you'd like to, or to remove the letter of instruction entirely. It has not been issued until it's ratified by you.
And that's my understanding as well, just from my, and I know it's uncomfortable from the perspective that I know you're all new and you weren't part of the process. There is, unfortunately, there is no, at least procedurally, the ability to be, it's my understanding, my reading, that there is no, what Ms. Ramos says is correct regarding that. However, with regarding to the letter of instruction, it can be changed. A decision could be made to amend it, or a decision could be made not to send it at all. At the end of the day, it is our letter, and we do have that decision to make. And if we need more time, that's something else as well. So I just want to make sure that we have we make an educated decision, and you understand what the options are as new commissioners.
This is the final question.
No worries.
I understand looking at this, how the language be confusing. Do we have any idea how much other confusion has been caused? Has this issue ever come up before the commission in terms of this language being confusing? Or are
Interesting.
we assessing it based on, you all have looked at it, thought it was confusing, Ms. Sarah thought it was confusing?
That's
That's
correct.
the instruction to the county.
We have not, at least I've been here almost 9 years, Mr. Mossky's been here a lot longer than that. I don't think either of us have ever seen this particular situation come up before. Why, I don't know.
Thank you.
And if you've read the letter, it says there that in the last paragraph, we hereby instruct and advise the Miami-Dade Procurement Department to clarify both Appendix D and the language and also the citation documents to accurately reflect the exact language of the section so as to avoid a similar situation occurring in the future. So we are trying to be proactive and make an effort to hopefully have them follow up with that recommendation. Any other questions from any other commissioners? Do I have a motion? Do the commissioners need more time to address this? We could put this on for next month. It's up to the board of commissioners. Any more time to review it, Renee?
Yeah, I'm gonna motion to, I don't, I understand the procedural rules, and obviously we've come to that hurdle, and obviously 3 of us were not here, so I don't want to get into the issue of this particular, and certainly not the 2 parties, one party involved and other parties, but I do think that I would like to see a little bit more emphasis on the county, making sure that situations like this don't happen as we move forward, that you don't have this, I would presume the county procurement department and county legal staff would review all this documentation before this goes out. I'm more interested in sending the message to the county that they need to do what they need to do as county staff to avoid a situation like this in the future.
I'm sure that Mr. Centerino and myself could meet with the procurement director and address the matter with her, aside from sending a letter, if that makes you more comfortable.
Yeah, I just, having been in government previously, I just hope that the meeting has fruitful goals and let's call it conclusions where the procurement director, is that correct? Would actually make sure or take some action, even along with county legal staff, that a situation like this wouldn't happen in the future. I mean, I'll be honest, I wasn't here when this decision was made, so, and I understand and agree with your recommendation that procedurally there's limitations, but what I'm more concerned as we move forward is that either of these individuals that spoke today, Mr. Melton, not be put in this could happen again for anyone if you don't have clear language as we move forward. And as Mr. Centerino knows, I believe that if we can send a message to the county that we need to avoid this in a very forceful manner, and maybe a meeting would satisfy, I'd be fine with that. I think that's a fruitful, something fruitful will come out of at least what I'm hearing here today for the first time.
If I could make a suggestion, and I know that Ms. Singer is aware of this, I'm not sure if they've actually, what they've done in terms of changing the language. I assume that they have already addressed that. If they haven't, though, I'm sure they will shortly. Perhaps, I mean, I know Ms. Singer very well, I could ask her to come before the board next month and to explain what, you know, from their perspective, what changes have been made, and to maybe to hear the commission's concerns about preventing this type of thing from happening again.
Because I think what, I understand the purpose of the letter, but I think I'm lacking information about how common this level of confusion is. And I'm assuming Ms. Sarah acted completely in good faith, so I'm not saying anything to impugn her reputation. But to do a letter of instruction when this is the first time in years that this has ever come up is a little concerning to me, because I don't know how common this problem is. And if it's an easy fix that they can do without a letter of instruction, or at least that more information to me, that's where I'm a little bit uncomfortable.
I like the idea of having that come before. I think what I'm hearing from my fellow commissioners is that is something that they would welcome. And I appreciate the concerns that my fellow commissioners have shown as to this. With regards to the letter itself, is this something that we want to wait to approve, or do we want to go ahead and send it and have the procurement department representative before us at a future meeting? What is the pleasure of the commission?
I don't know why you're looking at me. Look, the bottom line is, you know, if we want a motion to move forward, I'm fine with supporting the motion to move forward, but,
When you say move forward, can we clarify, you saying that you're comfortable with the language in the letter, you wish to amend the letter?
but I think the language is clear enough. My concern with many of these issues is that obviously, whether it's the first time or the umpteenth time that it's occurred, it is obviously a confusion that's led to two individuals being here. And my concern is, as it always has been when I've served on these boards, that something fruitful actually come out of this process. And my concern is that we send this letter on, and nothing happens with the recommendations made by this commission. I don't know if a similar problem will happen again. It may be years before it happens again, like Mr. Ramos said. It may not. But I'd like to send a clear message to Ms. Singer and the county and the procurement department that this is an issue that we're taking a lot of time on, and it needs to be corrected. If the letter is not enough, then I would prefer to have her come and make a decision at that time. Obviously, it doesn't look like a second to move it forward is something that was brought up until right now. And I'd like to hear from my other commissioners if they would feel more comfortable to have Ms. Singer come here and then make the decision. I'm fine with that. But with Ms. Singer, if she does come to the next meeting and we move this letter forward, I still want to bring this issue up to her to let her know that this is a problem. If it's going to be her just coming here and saying thank you, we'll take it into consideration, and all that good stuff that happens in government bureaucracy, then I'd rather not have her show up.
Well, it was my thought to have her come in and explain what action has been taken to deal with the issue that they've been made aware of, which I would think hopefully would be satisfactory.
So why don't we go ahead and table it? It doesn't seem that the commissioners are comfortable at this point approving the letter. Let's go ahead and table it for this meeting, invite Ms. Singer and appeal before the commission. Is everyone comfortable with that?
You have to make a motion formally to do that.
I guess we do. I guess I could make a motion myself. I was the only one present that has knowledge of this, so my recommendation to the commission, if somebody wants to make a motion, would be to table this to the next meeting and have Ms. Singer and the procurement department present so that we can address what has been done, because apparently this has already come to their attention and steps have been taken to correct this in the future. So that would be my recommendation to the fellow commissioners. Do I have a motion to that effect?
I'll motion.
Or any other?
I'll motion to table until such time as Ms. Singer I guess you're proposing, Mr. Chair, and I will defer to the chair, as he was the only one of us, at least here today, that was here, until the singer appears before this commission.
Second.
All in favor?
Aye.
Any opposed? Hearing none. Thank you, Mr. Munson, for being here, thank you, Ms. Sarah.
Thank you.
Thank you
Wait
for
one
your
second.
consideration.
Let's hear the next one. There's one more item. There's one more item.
Okay, let's move on to the next item in open session is Cecil Campbell and Ernesto Perez for status.
Good morning, Commissioners. Yeah, this case is on for status. Last month, we made a finding of probable cause in the case. It's a complaint that I filed against Ernesto Perez for unregistered lobbying. Since the finding of probable cause, Mr. Michael Band, esteemed attorney in South Florida, is representing Mr. Perez. We've had some conversations back and forth. And I just want the record to reflect I'm giving Mr. Band now the discovery in the case, which includes some sworn testimony from some witnesses, as well as a CD from another witness. And we'll move forward in the discovery process. At this time, I would ask the Commission to authorize, for my purposes, the issuance of 2 subpoenas in case I need to depose Mr. Perez and one of Mr. Perez's employees. I'm not sure I'm going to do that yet, but I'd like to have the subpoenas handed.
Is that correct? Any comments, Mr. Band, other than the esteemed part, I don't know where that came from. There's no need for that. He is an attorney, he is representing Mr. Perez. Any comments, Mr. Band?
Good morning, Mr. Chair, members of the Commission, Mr. Senorino, my esteemed colleague. Mr. Morawski has accurately stated where we are in the process. As I understood, probable cause was found. We are involved now in the discovery stage. He asked if he put on for status so we can inform the Commission where we're going. I'm not sure yet. I've gotten approximately an 1.5 inches along with a CD of documents. I intend to move as expeditiously as possible. Whether or not I will be issuing subpoenas to depose people, I'm going to have to go through this. I think we all recognize we're in summer. Summer is not an easy time to procure folks in and move things along as quickly. I don't know if you want to set it for a status report again, or if you just, I've had I think a reasonably good working relationship with Mr. Morawski in matters in the past. I believe we will continue to have so. We may be able to reach a resolution. We may need to schedule a hearing, but we're prepared to
Set it for
engage.
status in 2 months, September?
That's fine.
And as far as the subpoenas, the Commission...
You need a motion? I'll motion to
approve the subpoenas.
approve the subpoena.
Second.
Second, all in favor?
Aye.
Opposed? Hearing none. Go ahead and show us, please.
Thank you for your time. Enjoy your summer.
Thank you, Mr. Band. Thank you for doing that. Likewise.
Now.
Our next order of business in closed session, we have C
Excuse
me.
25.
I
Oh, I'm
have
sorry.
my parking ticket, which I was here at 9:50, and I called Mr. Santorino to tell him I would be late because it started to rain, but I have public comment and it's only 3 minutes.
Ma'am, I'm going to go ahead. What is your name, ma'am, and your address?
Nancy Lee, 20448 Northeast 34th Court, Aventura,
I'm sorry, last name? Lee?
Lee.
Miss Lee, I will provide you that opportunity. In the
I-
future, if you, yeah, and I understand you were here, but maybe you weren't aware. But go ahead and take your 3 minutes at this time.
Okay, I have 2 things I'm going to talk about, and one of them might even not have anything to do with you guys, but I just want you to hear it. First of all, with ethics complaints, the complainant is not contacted before the closeout letter. The accused simply says, "I didn't do it," and is taken for his word. The complainant might have additional information. So I'm saying that we should be contacted before the closeout letter to see if we have additional information. I've had many things before the board, and I've never been contacted. All of a sudden, I get this closeout letter, I go, that's a lie, and I can't do anything. Okay, the second thing is, the GOB bond money is being misdirected. Burgess and Nero put GOB bond money of $10 million for big projects, for infrastructure and whatever. The county is now using it for parking lots for Smokey's Barbecue and different things like that. And this was supposed to be really big projects. And I've spoken to Mr. Nero, and he thinks this is horrible, but he won't talk because he's mad. Anyway, doing these things during the summer is just not right for the public. We're doing the home rule charter changes during the summer. And you heard Mr. Perez's attorney, it's during the summer, nobody's here. So we're doing the home rule charter during the summer. We're redirecting GOB bond money during the summer. And I just don't think it's fair to the people here that these really big decisions are being made during the summer. And I was hoping that you might write a letter that the ethics of doing these things in the summer that are very important to the entire community is, might not be the best policy. Thank you. Oh,
Thank
I
you.
have 47 sections. Welcome everybody that's new here.
Thank you.
Thank you, very kind of you. Thank you, ma'am. Our next order of business is in closed session. Mr. Ramos, Mr. Morosky, is there anybody here that needs to remain present?
Not on the first case.
To approve it.
I move to approve it.
We have a motion. I'm sorry.
I thought he was making a motion.
It's okay. I'll make the motion either way.
And some, and I'm
I'll make
guessing-
the motion either way.
and Dr. Virginia second.
All in favor? Any opposed? Motion passes. The next one we have C-1428.
I'd say, motion for no probable cause.
We have a motion to make a finding of no probable cause of C-1428. Do we have a second? All in favor? Any opposed? And just so we're clear, it's a motion for determination of probable cause. We considered it, and the motion that you're making is to make the finding of no probable cause, which was first and second, and so that's why the determination was made.
If I may, Mr. Chair, the
Yes.
motion should include a motion to dismiss for lack of probable cause.
Motion to dismiss, that's correct, I'm sorry.
I'll amend my motion to include a motion to dismiss.
For lack of probable cause. Do I have a second? The motion's been amended. Procedurally, you're absolutely right, and I apologize. It should be a motion to dismiss for probable cause. There's been a first, a second, all in favor? Having that amendment, the amended motion passes. The next one is number 3. The third one is C-1429.
A motion to dismiss complaint due to legal insufficiency
No probable cause.
and no probable cause.
Not sure.
When each put the
It
probable.
doesn't go to probable cause if it's not legally sufficient.
That's right. So we have a motion to dismiss for legal insufficiency. Do I have a second? All in favor?
Aye.
Any opposed? And that was C-1429. And while this issue, so before we get to the subpoenas, I know Ms. Lee, who is not here, she brought up the issue of the complainants having the opportunity before the final determination of probable cause, whether a complainant is given the opportunity to be heard. And I did show the concern with my fellow commissioners, and I did want to address it with the advocate, who was going to elaborate for us as to what the procedure is and whether investigators make a determination or certainly have the ability to go back, not only to go and look at those that have been accused of the violations, but go back to the complainant as well for additional information.
Yeah, I just want to clarify what Ms. Lee said. She wasn't, she said closeout memos. She didn't say complaints. And I've known Ms. Lee for a pretty long time, and what she's talking about, and the distinction is, if there's a formal complaint filed, let's say when Mr. Cresswell files a formal complaint that comes in front of you, you know, it's pretty much our standard routine is we're gonna contact the complainant at some point to find out what information they have. I mean, that would go without saying. The kind of things that Ms. Lee was talking about is where we just get some information about something where there's no formal complaint filed. Ms. Lee, I don't know if she mentioned it or not, but she's a blogger. So she puts a lot of things out on her blog, and occasionally my investigators will look at her blog and say, hey, look, she wrote this article, there's something here, maybe we should go take a look at it. Now, to be honest with you, in a lot of those cases, we're not going to go talk to Ms. Lee, because if we do, the minute we do, she's going to start blogging that the Ethics Commission is conducting an investigation about something that she blogged. So if we don't talk to her in some situations, that's probably why. Now, if it looks like that, whatever she blogged about is going to become and may become a complaint, towards the end, we may go talk to her, but that's probably the explanation.
I've got a question, Mr. Brodsky. What about let's just say, non-blogging or non-public individual that files a complaint? Are they given an opportunity after, in other words, as I understood her, and I understand it's a little bit maybe different scenario, but is a person, if someone makes a complaint and you speak to the person that complains about, do you go back to the complainant and say, hey, this is what that person said, can you clarify your point of view? Do you give them an opportunity to come back and give you more information?
Sometimes. I mean, most of the time, we don't, we may come to a conclusion that after speaking to the people, everybody involved, and we say, okay, look, our determination is going to be no probable cause. Typically, we don't call up the complainant at that point and say, hey, Mr. Melton, by the way, you know, that complaint you filed, we're going to find no probable cause, because you know what ensues, all of a sudden they'll start coming back and saying, how can you possibly find no probable cause? Of course what I'm saying is right, of course I'm right and you guys are wrong. So, you know, typically, we just don't do that. We do speak to complainants, people who come in here to give us information to complain about things, even though they're not filing a formal complaint. That's what my investigators do all day, is sit down and talk to people who are making complaints.
I guess then the only other follow-up question I would have is, do you tell the complainants at the time that they come in that if they do have additional information, your door is open to receive that information?
Absolutely. I mean, that's what my investigators do. They go out and contact people. We're constantly talking to each other about what's going on with any particular investigation that's going on. Always the suggestion is talk to the complainant, get the information from them. If we find something wrong, you'll go back to the complainant, find out what's going on.
Under what circumstances are you not going to go back to the complainant? You said sometimes you do, so when do you not go back?
I mean, it's hard to say, but like in a situation like that where these investigations that we're doing are confidential, so if we don't want to tip everybody off, we're not going to go back to the complainant, because complainants call us all the time and say, hey, what's going on with the investigation? What's going on with the investigation? And we routinely tell them, look, I appreciate you gave me the information, but I'm not going to give you a status report of what's going on with this case. When it's over, you know, we'll get back to you. But
So I guess it's not really a status, so I'll just give you the context for my question. I spent years handling an ethics hotline complaints and hundreds and thousands of people we would talk to. And you definitely would say, we're not going to tell you what the conclusion is, you'll kind of find out what it is, etc. But we always, unless there was some extraordinary reason, might go back and say, I just want to clarify X or Y, unless we couldn't find the person or there was some real reason why we should. So I'm wondering if there's, we had a protocol for that, because kind of our best practice was, you know, everybody we talked to could be a liar, or everybody we talked to could shade the truth. And there might be, so before we finally go and close it out, is there something you want to go back and say, you know, by the way, you've heard this, this, and this. Can you amplify this? Can you clarify this? Why might people be saying this? So I'm wondering, is that the normal protocol and the exception not to go back to people, or is there not a protocol?
I'm going to tell you, there's nothing in writing that says this is the procedure that we follow. I mean, it's more of a case-by-case basis and you know, judging how the facts come out in every case. But we definitely have an open line to complainants who come in here and give us information. That happens all the time.
Thank you.
Am I entitled to,
With regards to, so Mr. Cresswell, if I can finish. With regards to the flexibility of the investigator, nothing precludes them from going back to the complainant and asking them additional questions, correct?
Absolutely not.
Because I like the idea of best practices. I've always been a big believer, and I talk about the public trust a lot. The more open the system and the more communication, I think the better. I think there's the other extreme too, and I understand that. But I do want to emphasize the need for that public trust and to make sure that they're aware that we have the open lines of communication. As far as giving them a status report every time they call, somebody could call every day. I get it, and it would become to the extreme. But perhaps there should be best practices. I wouldn't call it manual, but certainly some points
Actually,
of guidance.
Mr. Chairman, in the past, what we used to do when we did these sort of K investigations and we just closed them out, we would never notify the person who gave us the information. We've changed that procedure, and now we actually do a report and send that person a copy of the report. And oftentimes people call us up. I just had a lady the other day in here saying, hey, I got that closeout and I disagree with all this stuff that you found. And I sat with her for like a half an hour and I said, listen, okay, tell me what you disagree with, send me an email, and we'll look it over, and if there's something we see here that we missed, we'll go back and find it. I mean, that happens all the time.
Right, but is it too late at that point? Or
No,
we need a commission?
nothing happened. All we did was close out our investigation. We could reopen.
Mr. Presswood?
So then there's no appeal from the probable cause, no probable cause, but there would be, I don't want to call that an appeal, but a kind of a reopening of a case.
Right, if it's not a formal, again, there's this distinction between these sort of investigations that are going on where there's been no formal action taken as opposed to a formal complaint.
Thank you.
Mr. Presswood, I know you know that we already had the public comments, but if you have a brief comment on this issue, please limit your time.
So, several specific instances. Last year, I filed a complaint against Commissioner Sarnoff. He and his wife took a trip to Brazil. The commission found probable cause. The commission allowed his attorney to come back before this board 3 separate times to argue that the commissioner should not have his name, should not have the word probable cause in the letter of instruction. 3 times. They sat here for hours and argued this. I was never once, even though I was the complainant and had information, additional information based on what was being presented to the commission during these 3 sessions, was never allowed to say a word. Then there's the case of Mr. Angel Zion, the Chief of Communications for the City of Miami. He got a traffic ticket, reckless driving. I filed a complaint because the ticket had not been filed with the clerk of court after 30 days. So, found no probable cause. But it was a poor investigation because I went and did my own investigation and went to the Traffic Bureau and discovered that the ticket was only entered into the system after I had written my story. And the people at the traffic court were really concerned about that because of the way that the ticket was entered anonymously. It wasn't entered through the regular system. It just showed up. That was valuable information. Then there's the case of Mayor Regalado. I filed a complaint. Again, he took a trip to Peru. Didn't report it. His daughter reported it. She went on the trip too. She's a school board member. 2 weeks before the hearing, I notified Mr. Borowski. Sent him that information, said you might want to be aware that the school board member, who is the daughter, reported this trip on a Form 9, but the mayor did not, based on my complaint. Well, Mr. Borowski got up here and told the board members, well, Mr. Barnaby Min, Assistant City Attorney, advised the mayor that he didn't have to report this. The only problem was that Mr. Barnaby Min got fired from the city in February of 2013 when he was with the Planning and Zoning Board and wasn't hired until late October when the new city attorney came in and hired him as one of her deputies. So during the time when Mr. Regalado was supposed to have been advised by Mr. Min that he had, he didn't have to file a report, he wasn't a city employee. Now, that's a pretty important fact I think you would need to know if you're making a decision on probable cause and you're told, well, you know, it really wasn't the mayor's fault. He got bad advice from an attorney. He couldn't have got bad advice from the attorney because the attorney wasn't even working for the city, right? And then there were other documents related to, to rulings that this commission had made to Mr. Regalado specifically that were never included in the presentation to the members of the board. That's the issues I have. Because when you say, well, we make the presentation, but you know, if I'm sitting here and I hear that Mr. Mims said that he told the mayor he didn't have to report it, and I know that Mr. Mims wasn't an employee of the city, right? Then I think that's a material fact that needs to be known. So that's it. That's the concerns I have. And that's the concerns other people have. Because these investigations aren't necessarily done correctly. And like I said, people lie to you. Lie to you all the time.
We've given you almost an additional 4 minutes, and I appreciate your comments, sir.
That's it.
You can be reassured that the commission listens carefully, and certainly the new commissioners, and that's why I certainly give you the opportunity to speak so that we can all be vigilant and make sure that we are vigilant of the public trust, and that's why we brought it up here at this time, even though it wasn't formally on the agenda. It was brought up in a public comment by another individual, so thank you. We had some subpoena requests.
Yeah, they're done.
They're done. Okay. Any old business? Hearing none, do I have a motion to adjourn?
Motion to.
First and a second, all in favor?
Aye.
No opposed? This meeting is adjourned. Thank you.
Okay. So you're going to call, what's her face?
I have to call in Peg Gleason. She didn't return my call.
But I mean, but that's my argument. I mean,
Yeah,
you know,
it makes sense.
Yeah, no, it's a file,
I'll
just,
tell you right when you're right.
yeah, no, it's.